Andy McCarthy, a National Review contributing editor, the Institute's senior fellow, and a former chief assistant U.S. attorney general. We won't hold this against him. He was a former U.S. attorney in the District of Manhattan, so let's leave that alone. Andy, how are you?
Glenn, I'm doing great. How are you?
Very, very good. So let's start with the big story, I think, and that is the Supreme Court and what they were arguing last week. Can you give me your honest take on what this is really about for the future beyond Donald Trump, and how you think this is going to affect what is happening with Donald Trump?
Glenn, I think it's important that you frame the question that way, because it seemed to me, and I reread the transcript over the weekend after listening to the oral argument, the court is a lot more concerned about the presidency than about Trump.
Sure, it should be.
And it's an important point to make, because a lot of the coverage has been this hysteria over whether, the Trump-packed Supreme Court is in the tank for him and they're going to get rid of Jack Smith's prosecution. I don't think that's going to happen at all. It's possible that Smith won't get his case to trial, depending on what the court does. What I think the court's going to do is send the case back to Judge Chutkan, who is the trial judge in Washington, with instructions to sort out what things in the indictment against Trump are what you would call official acts that might arguably be immune from prosecution because they go to the core responsibilities of the presidency, and what are private acts or private wrongs that he would not have immunity for, even though they happened during his presidency. But the upshot of the questioning of the lawyers, including Trump's lawyer, and this is particularly by Justice Barrett and Justice Kagan, Trump's lawyer admitted that there's a lot of conduct charged in the indictment that is private conduct that really wouldn't be covered by an immunity claim, even though Trump's been saying a lot of stuff about absolute, complete immunity. And I think the concessions he made in the argument, that is John Sauer, Trump's lawyer, would be enough if Smith was willing to tailor his indictment down to the things that Sauer conceded. They could go ahead with a trial on just those acts. He'd lose a lot of evidence, but he probably should.
So what are some of the acts that could fall under, private, and so you could prosecute, and what are the acts that are the president and you don't prosecute?
Yeah, so the one bright line we can take away from this is that there seems to be a consensus that there is a divide between office seeking and the carrying out of the duties of an office. So if something is purely in the nature of trying to get reelected, that's deemed to be private because it's not part of the duties of the presidency. But it would be the same for anyone who was seeking office, whether that person was an incumbent or not. And then there are other things that are clearly presidential. So just to give some solid examples that came out of the argument, Trump's lawyer conceded that if Trump made a private scheme with private lawyers to get slates of electors designated for him and to supply documents to the Congress suggesting that they were the authentic actual slate of electors designated by a state, that would be private conduct because it's purely office seeking, and he carried it out only with private lawyers. On the other hand, there's an allegation in the indictment that Trump tried to use the Justice Department to signal to states that there were serious concerns about fraud and considered both removing the attorney general when he got pushback and considered sending a letter that they never sent from the Justice Department to the state of Georgia to tell them that they needed to do more scrutiny over what happened in the popular election. Trump argues very strongly, and I think the court will probably go along with this, that is the president's control over the Justice Department is purely a presidential act that should
Correct.
have no part in a criminal prosecution. So those are the kinds of things that the court is talking about sorting out.
But Andy, when Trump sat another group of electors, or tried to, that's what the Friends of Dershowitz did. I don't remember all of the attorneys in the 2000 election. That's what they were recommending to be done. You have to do that, or you have no case.
Yeah. Well, let me just be clear, Glenn. They're not saying that Trump wouldn't have a defense at trial. What we're talking about now is purely immunity. That is, could he prevent the trial from happening in the first place? I think that there's significant defenses to the fraudulent electors claim, beginning with the fact that the electors themselves didn't think they were fraudulent. They thought they were contingent. They thought that basically they were sitting in as the slate of electors in the event that Trump prevailed either in the state courts or with the state legislature to throw out the popular election. Then that would activate. But they weren't trying to fool anyone into saying that they were the actual electors that had been certified by the states.
Can he get a fair trial on that if indeed he has to go to court?
Well, I think it's tough for him to get a fair trial in Washington.
Why can't someone make the case here? Why can't his people make the case that you can't get a fair trial with the jury pool in New York or in Washington, D.C.?
I think Trump's problem is he's too famous in some ways. I mean, the problem is that unlike almost any other defendant, he goes into, one of the things that they can always say about him is he's the most famous guy in the world, and no matter where you had the case, you would have the same pretrial publicity problems. And they kind of reject out of hand the thought that because a jurisdiction votes substantially against Trump as a political matter, that means they can't be fair to him as a legal matter. You can debate that all you want about whether that's a sensible distinction to draw or not, but it is the distinction the courts draw.
Okay, so what do you think is coming down the pike on this? Go ahead.
Yeah, I think that they will send the case back to Judge Chutkan with instructions to go through the indictment and figure out what's a public act and what's a private act. If Smith wants to fight on that, then he's never going to get to trial prior to Election Day, which, of course, is his big aim, because this would still be a live immunity claim, and immunity is one of the few things that you can actually appeal pre-trial. So I don't see how he would get to trial. But I do think Smith, if he wants to, and if it's that important to him to get to trial quickly, he could say, you know what, I'm going to dispense with all of the acts that you say are immunized official presidential acts, and we'll just go to trial on the private stuff. It would be a weaker case for him, but it wouldn't be an unwinnable case.
And what is the punishment?
Well, that's an interesting question, because that may depend on another Supreme Court case this term, the one that they argued a week before on the obstruction statute that's key to Trump's case. That obstruction statute has a 20-year penalty, and it's the two main counts in the indictment against Trump. The other two counts only have, I think, 5-year penalties. So if the Supreme Court says that it rejects the way the Justice Department has been using the obstruction statute, which it might, then that would require probably a big overhaul of Smith's case, because those charges are very important to him. But if the court upholds that statute, which it also might, then you're looking at a potential of 40 years imprisonment. Now, he won't get 40 years, but statutorily there would be availability of 40 years imprisonment on those charges, and I think 10 on the other two. The other two are fraud on the United States and the civil rights charge. So he'd be looking at, statutorily 50 years imprisonment, which would indicate under the sentencing guidelines that he would get, I would think, 4, 5, 6 years of a sentence if he gets convicted on those charges.
It's unbelievable. Last week the Biden administration was making the case, well, Donald Trump's the only one that's ever broken the law. That's why we've never had this before. That's such crap, and we all know it. Why haven't we had this problem before?
I think a lot of the potentially prosecutable criminal conduct has come up late in presidential terms. Like, for example, with Clinton, the pardon scandal happened as he was going out the door. And I was in the Justice Department at the time. There was over a year of pretty intense debate within the Justice Department about whether he ought to be charged with bribery or not in connection with those pardons. But I think there's always been, maybe this has changed now, but there's always been a current of, like, when a new administration comes in, particularly if it's a new administration of a different party, they don't want to revisit what happened with the last guy. They want to just go ahead on their own stuff. This whole idea of, we're looking forward, we're not looking back. And I think that certainly had a lot to do with why the Bush Justice Department didn't prosecute Clinton. And I think with Obama, there was a lot of rhetoric during the 2008 campaign about war crimes against Bush and all that stuff. But when they got into power, they not only weren't interested in prosecuting anyone on war crimes. I mean, they reopened the CIA investigation, but then they closed it. But they actually ended up adopting a lot of Bush-Cheney counterterrorism. Mm-hmm. So, I think there's a lot of rhetorical campaign stuff about how, lock her up and we're going to put these guys in jail. But that it doesn't come to pass. I actually think Trump is serious about it this time because he sees what they've done to him. And that's why I thought it was amusing in the Supreme Court argument for the government lawyers to get up and say, you don't have to worry about this. This is just sui generis with Trump. It'll never happen again. And in the meantime, Trump is ahead in the polls, and he's running as the retribution candidate. He's promising if he gets in, he's going to do this stuff, right? So it's an amazing time to be alive, right?
Andy, tell me about how Alvin Bragg's doing so far.
It's a terrible case. I think I wrote a column about this today called How Judge Merchan is Orchestrating Trump's Conviction. And I was reminded of, the fact that Trump, when he was a young guy, learned a lot about litigation from Roy Cohn. And, what Cohn used to say, his first principle of hardball litigation was, don't tell me what the law is, tell me who the judge is. Mm-hmm. And I think Trump knows that. He knows it very well. And as I'm closely watching the rulings that are being made and the arguments that the judge is allowing to be made, it's clear that he has allowed Bragg, just so people understand, Glenn, this case is indicted as a falsification of business records that occurred in the months of February through December of 2017. Those are the only charges in the indictment. The case is being presented to the jury as a conspiracy from 2015 through 2017 to steal the 2016 election by violations of federal campaign finance law, which Alvin Bragg, as a state prosecutor, has no authority to enforce. And that's the way the case has been framed by the prosecutor based on orders from the judge. And that is the way that they are proceeding. And Judge Merchan is allowing the state to prove that Michael Cohen pled guilty to 2 campaign finance offenses, and that David Pecker, the AMI guy who ran the National Enquirer, that they had a non-prosecution agreement from the Justice Department and then paid a fine of $180,000 to the Federal Election Commission for violating federal election law. Now, it's a black letter principle of law that one persons, let's say person A, his guilty plea is not admissible evidence against person B, even if A says that A and B acted together. It's absolutely improper for these for this evidence of what Michael Cohen and David Pecker were thinking about the federal election laws, the fact that they made deals with the government. None of that stuff should come in. The judge is letting it in, and he's not letting Trump explain to the jury that he, Trump, was not charged by the Justice Department or the FEC, and the reason is obvious. They didn't think that these were actually expenditures that were cognizable under the federal law. And he's also not letting Trump call an expert witness to explain campaign law to the jury. So what the jury's going to hear about campaign law is going to come from Michael Cohen and David Pecker. So it's a farce.
How is this a fair trial if you can't call people and you can't let the jury know truly the other side of it?
Yeah, it's even more fundamentally unfair than that, because in the United States, under the Fifth Amendment to the Constitution, you are entitled, if you're going to be charged with a felony, it's got to be on the basis of an indictment returned by a grand jury that explicitly says what the charge is. The indictment in this case talks about, false bookkeeping in 2017. The case that's being presented to the jury is a conspiracy to violate the federal election laws. It's mind-boggling that it's being permitted.
Wow. Andy, thank you so much. I appreciate it.
Thanks,
this would definitely lose in a higher court, don't you think?
I do, but I think it'll be cold comfort. I mean, Harvey Weinstein's conviction just got reversed last week. I think that took 3 years. Right?